Good afternoon. Good afternoon and welcome. We're going to come to order. Good afternoon and welcome to the March 20th, 2018 convening of the Baltimore City Board of Municipal and Zoning Appeals. Today's hearings will be very brief, as we're just going to hear the cases which are on our consent agenda, as well as deliberate regarding some matters which are on our docket. The following cases are being postponed and will not be heard today: 2017-45, 6500 St. Helena Avenue, Becky Witt, 2017-488, 2401 through 2417 East North Avenue, Justin Williams, 2017-489, 1833 through 1845 North Milton Avenue, 2421 through 2431 East North Avenue and Alley, also Justin Williams, 2018-4, 6500 St. Helena Avenue, The Hangar LLC, 2018-7, 2205 Cross Country Boulevard, Lee Giroux, 2018-19, 532 through 534 North Belnord Avenue, Mahmoud Nakay, 2018-20, 6216 Wallace Avenue, Daniel Ankry, 2018-22, 719 South Durham Street, Jordan Duncan, 2018-23, 1372 Washington Boulevard, Quinn Trong, and 2018-25, 6500 St. Helena Avenue, The Hangar LLC. If you're here on any of those cases will not be heard today. They're being postponed until a subsequent date. Everyone else, if you didn't hear your case called, that's a good thing, because that means that you are on our consent agenda. And so we can jump into that in just a moment. First, if you have a cell phone, pager, et cetera, anything that makes any kind of electronically generated sound, plays a ringtone, et cetera, we ask at a minimum that you please turn those devices to a vibrate only, if not off position. Similarly, to the extent that you need to have a conversation with someone, we ask that you please take that conversation out the double doors to your rear. The reason for those rules is pretty simple and straightforward. Those of you who are forward of the wall above you can see that there are 1, 2, 3 video cameras which are mounted on the wall up there, and there are 1, 2 video cameras which are mounted on the wall up here behind us. These proceedings are being streamed live for broadcast on the city's cable access. I guess the website for the city's cable access channel, as well as recorded for subsequent tape delay broadcasts on the city's cable access network, and stored for all posterity on the city's YouTube channel. So cell phones, pagers, conversations, and the like disrupt not just the general conduct of these proceedings, but also the recording of these proceedings as well. In addition, these proceedings are being recorded. These microphones which are arrayed around us up here are all very sensitive, not only for the purpose of amplification, but they're also for the purpose of recording these proceedings. And cell phones, pagers, conversations, et cetera, interfere with that process. Also makes it more difficult for a court reporter to be able to accurately take down any testimony or comments from the board. We are going to be voting at the end of the session today, and you're certainly more than welcome to hang around and enjoy a civics lesson if you so choose, but if you've got other things to do with your rather snowy, sleety, generally nasty, late March, first day of spring afternoon, that's quite understandable. And you can call into the zoning board office in the morning to find out how we ruled in your case. I can jump to the chase on that and let you know that if your case is going to be called today, it's going to be granted on the consent docket, which means that it's going to be, you don't need to call in for the morning, because your case is going to be granted at the end of our session today. But if you would like to do that, you can call into the zoning board office. I'll read that number off. If you would like to call in, that number is 410-396-4301. That number again is 410-396-4301. You will, however, need to wait until you receive the formal written notice of the outcome of your case, which should be forthcoming in about 3 to 4 weeks, before you will be able to get your permits. And that is a very important thing to remember, because even though your case may be granted in this session, our approval is not actually valid until you receive the formal written notice of the outcome of your case. So certainly don't do anything until you receive that. I don't expect that there would be any changes, but until you receive that piece of paper, then you won't be able to go on to the next step in the process. The procedure for the cases today, when your case is called, you'll come forward. Since all the cases on our consent agenda, everyone will stand to our left. If there was any opposition here, they would be standing to our right. But the applicants will all stand to our left, that is your right, and try to stay in the order in which you are called. That will make it much easier as we go through the cases. But once we go through the consent agenda, all the cases are called, everyone gets up here and in line. We'll then have you all sworn in as a group, and then we will call each case in turn, and you'll be given the opportunity at that time to offer any additional evidence that you would like to have added to the record. So the following cases are on our consent agenda today. 2018-21, 118 East Clement Street, Matt Nofel. Next will be 2018-24, 922 through 928 East Preston Street, Mount Sinai Baptist Church. Then will be, there you go, yeah, we'll just line up down there. Next will be 2018-26, 3825 through 3829 Falls Road, 3837 Falls Road LLC. 2018-29, 6615 through 6617 Harford Road, Natasha Wainwright. Then will be 2018-31, 333 South Clinton Street, Steve Carroll, followed by 2018-33, 2901 Eastern Avenue, A.J. Gordon, and then 2018-35, the east side of Sweet Air Road, 477 feet south of West 36th Street, that is block 3523, lot 67, James Anders. And finally, there'll be 2018-51, 2111 St. Paul Street, Nate Prettle. Okay, now that we've got everyone up here, if all those intending to give testimony in these matters can raise their right hands to be sworn, please.
We swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
All right, calling the first case on the consent agenda, 2018-21, 118 East Clement Street, Matt Nofel.
Good afternoon.
Afternoon, sir. We have this as an application to construct a 2-story rear addition and rooftop deck at this location. Is that correct?
Yes, sir.
All right. Mr. French, anything for the planning department?
Martin French for the Baltimore City Planning Department. Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Nofel, anything that you would like to have added to the record in your case?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal. Good luck.
Thank you. Safe travels tonight.
Thanks, you too. 2018-24, 922 through 928 East Preston Street, Mount Sinai Baptist Church.
Geraldine Stevenson, thank you.
Afternoon, ma'am. Can you repeat your name again?
Geraldine Stevenson.
Thank you very much. All right, Ms. Stevenson, we have this as an application to construct a 1-story rear addition at this location. Is that correct?
Yes, sir.
All right. Mr. French, anything for the planning department with respect to this application?
Planning Department has no comment on this application. Thank you.
Thank you. All right, and ma'am, anything further you would like to have added to the record?
No, sir, thank you.
All right, zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve the appeal.
Okay, thank you, sir.
Good luck, take care. Next, 2018-26, 3825 through 3829 Falls Road, 3837 Falls Road LLC.
Good afternoon, Caroline Hecker, Rosenberg Martin, on behalf of the applicant, and I'm joined by Amanda Bennett, who is the proprietor of the proposed Cat Cafe.
Afternoon, ma'am. All right, we have this as an application to use the first floor of consolidated structure as cafe with accessory fostering of 10 to 20 cats for adoption with second and third floor dwelling units. Is that correct?
That's correct.
All right. Mr. French, anything for the planning department?
Yes, thank you. Planning Department recommends approval of the application, subject to the condition that 3825 Falls Road is consolidated with 3827 Falls Road prior to commencement of interior work to create the cafe. Thank you.
Thank you. And Ms. Hecker, are those conditions stated by the planning department acceptable to your client?
They are, and in fact, the properties have already been consolidated, and a copy of the consolidation approval is included in the file that I would like to have added to the record.
Okay. We will have that added, and with that, is there anything further?
That's all we've got.
Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve the appeal.
Thank you
Good
very
luck,
much.
ladies. Take care.
Hello.
Hi. 2018-29, 6615 through 6617 Harford Road, Natasha Wainwright.
Yes, Natasha Brown Wainwright, sir. Yes, we are a state-approved production facility, and I basically want to add the status of city status to be able to rent it out to other artisans.
Okay. And ma'am, we have this as an application to use the property known as 6615 as a shared commercial kitchen. Is that correct?
Yes, sir.
All right. Mr. French, anything from the planning department?
Department of Planning reviewed the application and has no objection. Thank you.
Thank you. And Ms. Wainwright, anything further to offer in regard to this appeal?
Just some pictures of the space is already set up as a shared, as a production facility, commercial kitchen. So I just wanted to add it to the record, sir.
Okay. Anything further?
That's it.
Right. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve your appeal.
Thank you, sir.
Good luck. Have a good evening. Next, 2018-31, 333 South Clinton Street, Steve Carroll.
Yes, sir.
Afternoon, sir.
Good afternoon.
We have this as an application to construct a two-story rear addition with second floor rear and rooftop decks. Is that correct?
That's correct.
All right. Mr. French, anything with the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Carroll, anything further you would like to offer in this case?
No, sir.
Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal. And
Great.
that's good news.
Thank you.
Good luck. Take care. 2018-33, 2901 Eastern Avenue, A.J. Gordon.
Yes, should be 2903.
Okay, 2903. We will make that correction. Do we have that in the file?
We can check, Mr. Chairman, to
Okay.
make sure we have the correct property address.
All right. Okay, with that change in mind, Mr. Gordon, we have this as an application to construct a second floor rear deck and rooftop deck at this location. Is that correct?
That's right.
All right. Mr. French, anything from the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Gordon, anything further you would like to offer in the record in your case?
No, thank you.
Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve the appeal.
Thank you very much.
Take care. Next, 2018-35, east side of Sweet Air Street, 477 feet south of West 36th Street. That is the block 3523, lot 67, James Anders.
Yes, I'm actually Kelly Starr's agent for the owner.
Okay.
Last name is spelled.
S as in Sam, A-W-E-R-S.
How was your first name? I
Kelly.
blanked. Thank you.
All right. Ms. Sars, we have this as an application to construct a one-story, single-family detached dwelling at this location. Is that correct?
Correct.
All right. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And Ms. Starr, is there anything further you'd like to have offered to the record, added to the record in your case?
Yes, we would just like to add a letter from the Hampton Community Council standing, supporting this construction.
Okay. That.
Good.
Okay. Anything else?
That's it.
Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve the appeal.
Great, thank
Good
you.
luck. Take care. Last but not least, 2018, that's 512111 St. Paul Street, Nate Prettle.
Good afternoon.
Afternoon, sir. Mr. Prettle, we have this in application to use the premises as 4 dwelling units. Is that correct?
That is correct.
Okay. Ms. French, anything with the planning department?
Yes, thank you. Planning Department reviewed this application, noted that this property is located within the Charles North Urban Renewal Area, for which the Urban Renewal Plan does require a notice to proceed, which is now known as an authorization to proceed, for any work that involves the exterior of the property. The Department of Planning therefore recommends that approval of this application be subject to the condition that all exterior renovations and alterations, including window or exterior door replacement if done, are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you. Mr. Prettle, is that condition stated by the planning department acceptable to your client?
Yes, it is.
All right. Anything further?
Yes, I'd like to introduce Donna Mitchell, who's the property owner and resident, along with her husband. And I should add that they're moving from Anne Arundel County to Baltimore City, which we always love. And in regards to the planning department's letter, they're doing a full historic renovation of the property, the CHAP, MHT, federal tax credits, and it's going to be a great project. We have the support of the Charles Village Community Association. There's a letter in your file.
Okay.
Great.
Is that it?
That's it.
Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to approve the appeal.
Great. Thank you.
Thank you.
Good luck. Take care.
Get home safe.
Thanks. You too. All right. That concludes our docket for today. And I guess we've just got the,
Oh, that's right.
yes, Ford Avenue case to deliberate about 2017-429, 1200.
Yeah, this is on the record.
Start back up.
Sure. Deliberating on 2017-429, 1200 East Ford Avenue. And I guess actually we normally don't keep the our deliberation on the stenographer.
You wanna, okay.
Just cut it.
Yeah.
Yeah, that's right.
Yeah, we'll have that to file.
We do have the video. We can leave. Moments that. Okay. All right. So we heard this back in January, and we had deliberations postponed at least once, not taking any testimony or considering any other evidence, but just simply to vote. So, now, Derek, I can't remember if we had any legal input we were looking for with regard to this as well.
There was none specifically requested that I can recall.
All right, good. Okay, so we all remember sort of the general outline.
I can pass down copies of the staff report that we have.
That'll be great. Thank you.
Memories here. And for the record, Ms. Hecker submitted a summary memorandum of law on February 13th, just kind of outlining their points that were already raised at the hearing.
Okay.
And we also have letters of support from President of the Locust Point Community Association, Delegate Luke Clippinger, neighboring property owners. I believe there's a letter in here in favor, which I shouldn't say that because I don't see it. There was no opposition to this appeal when it was originally heard, January 23rd. Yes, there is a letter in support from the councilman from the 11th District, Eric Costello.
Okay. All right. Anyone else want to take a look at that? My issue with this, and it never really sort of moved off of it, as I continue to think about it, is just that the use isn't really a use to be made by the property owner. It's basically, it's creating outdoor dining for an adjacent landowner. I don't see, the idea was that it was gonna be an accessory use, and they also saying that, well, you know, if it's not accessory use, it's a non-conforming use. You know, I don't think it can be a accessory use because it's not. It's accessory use is supposed to be aimed at the primary use of the property, and it has nothing to do with the use of the property. It has everything to do with the use of the adjoining property.
The adjoining property, if my memory's correct, the adjoining property does not have any legal rights to this strip of land. Is that correct?
I think that, yes, that it was going to basically be to the exclusion, although I think that there was some suggestion that maybe people, if they wanted to come and, if workers wanted to come and enjoy their lunch out there, that they would be welcome to do that. But yes, this would be space, as I understand it, that would be leased by the adjoining landowner. And so I just don't really, I can't reconcile those, you know, the concept of you've got this one strip of land that's really being used for this other property owner, but yet it's supposed to be accessory, and I don't even think it can be non-conforming, because I think that the use was one that was made by the adjacent property owner, not the existing property owner. So that was my issue with it.
I guess I'm trying to remember the arguments here. If the Barracuda's owner leases this property, why isn't Barracuda the appellant here?
Because they're not the property owner.
Well, I know that, but you can have leased property and operate on
Yes.
leased property. I mean, it happens all the time. And I guess that's, it's just not making sense to me, and maybe I'm missing something, but it's just not making sense to me. If Barracuda's has a legal right to this property through a lease, through a license, through a something, then why isn't Barracuda's here as the appellant, as opposed to the owner of the property?
Well, I think actually it is. It says the applicant owns the adjacent property known as 1230 East Fort Avenue, which is improved with a restaurant known as Barracuda's Tavern. So the applicant
that
is
is the
Barracuda's.
applicant.
Yes.
Okay, my recollection was it was the, so the applicant is trying to use,
Somebody else's property.
well, no, and I still.
Well, still, yes. If they have a lease, they can authorize, you know, and they're moving forward with the permission of the owner of the land.
Right.
Sure, you can do that. But here, the argument for accessory, in my mind, doesn't work, because accessory goes to the principal use. It has to be, it basically has to serve somehow the primary use of the property. And here, it doesn't have anything to do with it, the primary use of the property.
Is there any authority that you could find? I mean, I would love to be able to figure out a way to make this happen. I just, I'm stuck.
The only thing that occurred to me was something that Frank had mentioned just now and at the last hearing, that there's no requirement, what's the best way to put this? You don't need to own the property to use it,
Right.
right? You
That's
can
true.
have a tenant lease
Right.
property
Yes.
and then has full right to use that property per the terms of that lease.
Right.
Mm-hmm.
Can the board grant an accessory use for a coffee manufacturing plant to also serve food outside? It's clear that the food is being prepared elsewhere, and to me, that's the determination that the board has to make, that is that allowable or not? Can you prepare food elsewhere and bring it on site and serve it as a valid accessory use? Or does part of that accessory outdoor dining have to be generated from the kitchen on site? In this case, there's no kitchen on site, there's no
Right,
restaurant, there's
right.
nothing on site
Right,
because
it's just
of the
factory.
weird property line.
I don't know.
Hold on.
Thanks,
When
Chris.
you go to the definition of accessory use, it's customarily incidental and subordinate to the principal use.
But if that area, I guess there would need to be a subdivision in order to lease just that area?
Well, no,
Or
they
does-
would
Not necessarily.
need to subdivide it to lease that space there.
Right.
I think it would be that they need to subdivide it in
that
order
would
to be
then
able to
be-
convey it.
Right.
Yeah, you don't have to subdivide to lease it. You can-
Right.
You can just carve it out.
So here's the,
So if they can show a valid long-term lease for that section? And the question is, would that satisfy?
So if the appellant, go down this road, if the appellant has a legal right to use the real estate, that strip,
Yes?
and the appellant, but again, I must be missing something here, the appellant could the appellant then, I guess this is what Derek was saying, could the appellant then use that as an accessory to the bar use? But it's not the same lot, that's where that
Yeah.
argument falls apart.
Right.
And the problem becomes how accessory is defined in the code.
yes.
Yeah.
That, to me, is just really where it all falls apart, is just when you get to the definition of accessory use in the code, it requires that the accessory, that there be some interrelationship between the accessory use and the principal use of that lot. And they have nothing to do with one another.
Yeah, okay.
Does a lease create any kind of possessory interest?
Well, that's what I'm
Yeah,
wondering.
it does. I mean, you can look at any.
Why the lot distinction if there is a lease?
Because it says on the same lot, well, it says on the same lot.
It is the same lot. The principal use of the lot is as a coffee manufacturing facility.
And you can't cross the lot line and get accessory use on somebody else's lot.
Yeah.
That's the issue to me. I mean, if you could.
Right.
Now, there's an argument here about non-conforming use. Saying,
Is there either?
saying that the, well, this use began in 2015. And so since it began and there was no testimony saying that it didn't, so here it says, in contradictory testimony that the outdoor lot was first established on the property in March 2015. At that time, the property was located in M3 zoning district, in which outdoor table service accessory to a restaurant was permitted by right. of course, the restaurant wasn't located on the property, and it wasn't, and so therefore it couldn't have been accessory even then. So, and then 203 provides that if a pre-existing lawful use is reclassified by this code or an amendment to it so that the use is no longer permitted or conditional use in the zoning district in which it's located, that use may be continued as a lawful non-conforming use. This basically is just sort of the traditional, if you've got a non-conforming use, you're allowed to continue it type of deal. You know, subsumed in that is that whole lawfully existing use part, which just simply gets us back to the accessory to a restaurant that's not located on the property thing. Creative, but I still think it doesn't jump over that hurdle. Now, Martin, I think you said that there was some issue with an inability to do a subdivision here, or some complexity that would make it hard to subdivide. If you're not recalling that, or if you just simply...
That was probably a reference to the fact that they'd have to create a lot of a certain size. That may have been what I was saying. I do not recall at this instant. And that might have required a larger lot than the area that's actually used as the outdoor dining area at the present time.
Gotcha. All right.
But you could potentially, oh no, never mind. That's more complicated than is necessary. Don't worry about it.
Were you gonna get into like adverse possession or something?
No, I was gonna, if they would somehow consolidate both the large and then re-subdivide out, but that's why that's a whole rabbit hole.
Yeah. All right. Well, that's something for another day, but I vote no.
Nope.
All right, and we're done.
So that was a no vote.
Threes.
For
Correct.
3, okay.
Off to the